Justice Jackson?
So I guess I'm going back to your discussion with Justice Kagan. I'm not sure I understand why you're characterizing the as-applied challenge in practice as the individual coming back and proposing a different classification, as though we're doing an analysis of the classification in the way that you suggest. I thought that the state has a classification that is its general rule. No individuals who identify as female but were sex at birth male can play in women's sports. And that the individual then is merely seeking an exception based on their individual capacity, because the state's general rule is based on fairness and medical science and all of these things. Do I have this, like, they're not proposing an alternative class necessarily. They are just saying that I should be accepted from that general rule on this basis.
We agree that an exception is what they are seeking, Your Honor. And it's an exception based on transgender status, again.
But that's the way the rule used to work, right? I just want to be clear about what we're talking about here.
Sure.
I understood that this law originally was exactly that. That you basically said no transgender women in girls' sports, but we'll look at your evidence and look at your circumstances and decide whether or not you individually can be included. So is that what used to happen?
As a matter of Idaho law, there was no law whatsoever before this.
Is that what was happening on the ground in Idaho law?
That's what NCAA policy permitted from 2010 to 2022. Before 2010, the NCAA policy matched ours. Since 2025, the NCAA policy has matched ours.
Okay. But what I'm asking is, if that's the ask here, not that all transgender women be allowed, but that this particular plaintiff be allowed based on their circumstances, why is that so not administrable or proposing a different classification that we're not going to be able to sustain? I don't understand.
So first as to administrability, Your Honor, making sure that a transgender athlete does not have an unfair advantage would require ongoing testosterone monitoring, because circulating testosterone can fluctuate. That is invasive. That is intrusive.
No, but that's the burden of the person. The person who wants to play has to demonstrate to you, to whatever degree of scientific certainty, that they don't have a competitive advantage. Why would you not allow that? I guess I don't understand.
The second answer is that there's nothing in that argument that limits itself to transgender identifying athletes. If this athlete doesn't have an advantage over women and therefore can compete safely, then there are other athletes that could say for different reasons that they don't have an unfair advantage and therefore they could compete safely.
Yes, and I understand that, and there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis of transgender status. The law expressly aims to ensure that transgender women can't play on women's sports teams. So why is that not a classification on the basis of transgender status?
I'd apply Skermeti again. The question is whether the application of the law turns on transgender status, and it doesn't. It turns on sex. The legislature did not want to exclude transgender people from sports. It wanted to keep women's sports women only and exclude males from women's sports.
No, I understand, but with respect to two individuals, a cis woman and a trans woman, who both want to play on a team that reflects their gender identity, this law operates differently based on their sex, right?
The law does operate differently based on their sex, as Your Honor just said. It does not operate differently based on their transgender identity.
But it treats transgender women different than cis women, doesn't it?
It has a disparate impact, because men who identify as transgender have a different reason for wanting to play women's sports than women, than biological females do, right? But if that were enough, then Skermeti would have come out a different way, Gaduldi would have come out a different way. other cases would have gone a different way. I'm blanking on the other ones.
All right, finally, let me just ask you about mootness, because it's a little odd, I think, that a defendant would not want a case dismissed. Ordinarily, the defendant is the one who's claiming mootness because they've been sued. So this plaintiff has brought a claim against you, and the claim relates to your policy about college sports. And as I understand, the plaintiff is about to graduate. So wouldn't we have a mootness problem potentially notwithstanding any representations that the plaintiff made?
I don't think so, Your Honor. I'd look to Camreta as the case that tells us the best case for telling us how we analyze mootness in this situation. It's, does the petitioner still have an interest in continuing the litigation?
Only for a few more months. What if this decision doesn't come out until June and she graduates in May?
It's my understanding at this point, I defer to my friends here, it's my understanding at this point that May graduation is not possible.
For this individual?
For this individual, that's correct.
All right, thank you.
Thank you.